Hey guys, my name is Ryan Nerney, and I am a managing partner at the nationally recognized security clearance, military, and federal employment law firm Tully Rinke. Welcome to the new podcast for the National Security Clearance Lawyers Association. This is the one and only podcast made to teach people from all industries that require security clearance, the ins and outs of the security clearance process, what adjudicative bodies look for in potential disqualifying and mitigating conditions, and what potential and common situations mean for your security clearance. Whether you're an employee for a government contractor, a federal employee, or a member of the military, I hope you'll be able to pick up some tidbits of useful information when you listen to the NSLA podcast. Today, for our very first episode ever, we're going to talk about the general process one must go through in order to obtain a federal security clearance and what the adjudicative standards are for the 13 National Security Adjudicative Guidelines. By the end of this episode, you'll be able to have a general understanding of what one needs to do in order to begin the security clearance process and what each step of the adjudicative process is for obtaining a security clearance. Let's dive right in. First, it's important to understand that one cannot just apply for security clearance. I get this question all the time in my practice. Hey, can I just apply for a clearance before I get a job? Well, the short answer to this question is no. You need to be sponsored by a government contractor or a federal government agency in order to start the security clearance process. If at any time you lose sponsorship, depending on where you are in the process, that could cause something called a loss of jurisdiction, as any adjudicative body will not be able to continue adjudicating your case if you lose sponsorship and thus no longer require a security clearance. Once you actually obtain a sponsoring company or an agency, then you'll be able to proceed with the actual application process. The application process consists of completing a security clearance application, or it's also known as a questionnaire for national security processing. It's also most commonly referred to as an EQIP. The EQIP can actually be a few different standard forms, either the standard form SF 85 for low-level public trust positions, an SF 85P for high-level public trust positions, and the commonly known SF 86, which is the standard form used by all government agencies for all clearances above a high-level public trust, such as a secret, top secret, a Q or an L clearance with the Department of Energy. It's referred to as an EQIP because it's essentially electronic. It's an electronic questionnaire. These documents request a lot of information about almost every aspect of your life. While the SF-85 does not request as much information, the SF-85P and the SF-86 request information about things such as where you live for the past 10 years, the jobs that you have held, any criminal conduct or drug use that has occurred over a specific period of time. The most commonly referred to time frame for that is 7 years. It also could ask about any foreign contacts and investments that you may have overseas. The purpose of these forms is really to determine if you are eligible to obtain and maintain a security clearance, or if you present a risk to the national security of the United States. This form is also used to determine essentially if you're being wholly forthcoming regarding the specific questions being asked. It's extremely important to be 100% honest on these forms. Even if you go several years with no issues after omitting or lying on these forms, I've definitely learned through my years of practice that it always catches up with you. These forms can sometimes be intimidating given just the amount of information it's asking for, and it can be very invasive. However, honesty is the key when you're completing these forms, so an honest and thorough assessment of your security clearance eligibility can be completed by the appropriate adjudicators. Now, once you're finished with the SF-86 process, and after you have submitted the security clearance application, you typically have an investigative interview where an investigator from a government agency, it's typically the Defense Counterintelligence and Security Agency, also known as DCSA, but it could be other agencies depending on what government agency is sponsoring your clearance. But the investigator in those investigations will go over all aspects of your SF-86 within that interview. These interviews can last anywhere from 1 to 4 hours, depending on the investigator, the amount of security concerns that may be present, as well as some other factors. The investigator may have one or more interviews with you regarding what you disclosed on your security clearance application. They may have some follow-up interviews with you after they have conducted other interviews with individuals that you actually named or disclosed in your application itself. This is a common part of the process, and the investigator's job is to gather the information to produce. Essentially, it's a report of investigation, which then goes to an adjudicator to determine if your clearance eligibility should be granted, or if you will have to go through the appeal process by receiving a document commonly known as a statement of reasons or an SOR. Any adjudicator, whether at the security clearance application review stage or after receiving a statement of reasons and responding to it, they will be focused on 13 adjudicative guidelines, commonly laid out in the Security Executive Agent Directive 4, which was put into place pursuant to Executive Order 12968. These 13 adjudicative guidelines consist of both disqualifying and mitigating conditions as guidance as to what potential security concerns the government may have, and then also what needs to be done to mitigate those concerns. These 13 adjudicative guidelines consist of Guideline A, which is allegiance to the United States, Guideline B, concerns under foreign influence, Guideline C, which are concerns under foreign preference, Guideline D, sexual behavior, Guideline E, personal conduct, and Guideline E, just for your reference, is the catch-all guideline. So if any security concerns don't fit specifically within one of these other guidelines, they usually throw Guideline E in there just to kind of cover their bases. Guideline F is financial considerations. Guideline G, alcohol consumption. Guideline H, drug involvement and substance misuse. Guideline I is psychological conditions. Guideline J, criminal conduct. Guideline K, handling protected information. This also includes any mishandling of classified material, things like that. Guideline L, outside activities, which is very rare. And then Guideline M, which is use of information technology. Whether it's an adjudicator at the security clearance application stage, one reviewing a statement of reasons response, or an administrative judge at an in-person appearance, each adjudicator will be evaluating your eligibility for a security clearance based upon these 13 adjudicative guidelines. Turning now to the security clearance denials and revocations. Prior to a security clearance being officially denied or revoked, an applicant for a security clearance will have an opportunity to respond to the allegations or security concerns that are routinely laid out in that statement of reasons that I mentioned earlier. Now, depending on the government agency, a person will have anywhere from 7 to 60 days to respond to a statement of reasons in writing. While most agencies allow for a written response and a hearing in the event the written response does not fully mitigate the concerns, agencies such as the Department of Energy only offer one or the other. You can't do both. Either way, a statement of reasons or a document that's similar to one of those will be issued, and you will be provided an opportunity to present an argument and evidence in order to attempt to mitigate the government's concerns prior to a final decision being made on your clearance eligibility. Once a statement of reasons is issued and you respond to the allegations, you typically receive a written decision within anywhere from 2 to 4 months, although some agencies can take upwards of 3 to 4 years to receive a decision. In the event that the written response does not fully mitigate the concerns that the government has, then typically a hearing or a personal appearance is allowed in order to give you another opportunity to attempt to further mitigate any concerns of the government. This is typically your best and last opportunity to mitigate the concerns before a final determination is made. While these hearings and personal appearances are administrative in nature, they still require the presentation of evidence in which the rules of evidence apply, along with the presentation of opening and closing arguments, submission of exhibits, and witness testimony. There's also an appeals process after the hearing stage for most agencies. In the event that a decision is made by an adjudicative body to deny or revoke your security clearance, agencies typically allow for an appeal of that decision, typically in writing. The type of appeal one is offered depends on the federal agency that's adjudicating the security clearance. Some agencies allow for in-person appearances as the appeal, where you can submit evidence and have witnesses testify on your behalf, kind of like they do in a general hearing, while others only allow for a written appeal where you cannot submit any additional evidence. This is typically for the Defense Office of Hearings and Appeals, which is the adjudicative body who typically adjudicates clearances for the Department of Defense. Appeals are the last opportunity for an individual to overturn a security clearance eligibility, denial, or revocation. In some circumstances, again, albeit rare, if you receive a favorable decision from a hearing or written response, the government could appeal that favorable decision. Essentially, each losing party will have the ability to appeal a decision in one way or another. The next stage, if your clearance is denied or revoked, there is an opportunity to reapply for a clearance in the future. In the event that your clearance is denied or revoked and you do not appeal, or even if you do appeal and you lose on appeal, you'll have to wait a certain period of time before you can reapply for security clearance. Essentially, you'll have to start from square one by obtaining a sponsoring company or agency, completing a new security clearance application, and then going through that adjudicative process. Most of the time, the time frame one must wait to reapply for security clearance is 12 months from the date of the final determination, or with the Department of Defense, with the Defense Office of Hearings and Appeals, contractors typically wait 12 months from the date of any administrative judge decision, regardless if you decide to appeal or not. It's important to note that if you do reapply for security clearance, you'll be required to address any allegations that were not previously mitigated before any new investigation on your security clearance eligibility can take place. While this is certainly not an all-encompassing description of what can and will happen during a security clearance application and adjudication process, it is a great guide to and gives you kind of a general overview as far as what to expect when you do apply for security clearance, especially if there are some potential security concerns. So there you have it for this month's NSLA podcast. Please keep a lookout for more content to assist with your current and future security clearance journeys. Thank you for listening, and we will see you next time.